Wilson case. Okay, would you please announce your appearances?
Yes, Your Honor. Daniel Paz for the movement.
Michael Wilson, the debtor.
Okay, Mr. Wilson, you need to step over to the lectern when you speak.
Very well, sir. First of all, good afternoon, Your Honor.
I just wanted you to announce your appearance.
Michael Wilson, debtor.
Right, we've got, actually, you've got several things that you've asked me to look at today.
Yes, sir.
And I don't know if I can look at two of them because I don't know whether the notice has been adequate under the circumstances. The motion for examination of a party, I believe Mr. Paz's client, and the motion to require them to, I'm not sure what you had in mind, but to prove that they have the capability to speak respecting the property, I believe. Is that right?
Yes, sir.
Okay. All right. Then we also have the objection by Mr. Paz's client to the debtor's section 362I1 statement, which is also to be regarded as a motion for relief from stay. Is that correct, Mr. Paz?
Correct, Your Honor.
Okay, I'm not sure. I think perhaps the best way to proceed is to start with Mr. Paz, since we definitely have sufficient notice in his case, and we'll go from there.
Sir.
Thank you, Your Honor. Daniel Paz for the Bluffs at Paradise Creek. Your Honor, in essence, our objection is asking the court to confirm that the automatic stay in this case does not apply to my client. Mr. Wilson has filed two bankruptcies. The present bankruptcy was filed on July 30th, 2014. Under 362, there is an exception to the automatic stay that does not stop actions related to an eviction that is obtained prior to judgment, or prior to the bankruptcy being filed, excuse me, Your Honor. And in this case, my client, the Bluffs at Paradise Creek, obtained a final judgment from the Tarrant County Court at Law number 1 on June 12, 2014, which was prior to the present bankruptcy filing that's before the court today. Within that exception, there is a savings clause that allows debtors to file a certification with the court, acknowledging that there is a judgment against them for eviction and allowing them to cure any default. However, under the Grigsby opinion out of the United States Bankruptcy Court, Southern District of New York, that savings clause has been held to be limited just to defaults regarding monetary issues, failure to pay rent. The eviction in this case that my client obtained against Mr. Wilson was for holding over.